All right, we should be back in the building. Y'all know what to do. Shout out to the gang up in here. Oh, shoot, I did not get the chat ready. Hopefully we should be good. Y'all know what to do. Drop a 1 in the chat if you can hear me. Drop a 1 in the chat if you can see me. We are back at it. Shout out to everybody who's in the building. I think I see the gang in here. Hold on a second. I see a couple of y'all in the building. We should be good. Welcome, y'all. Welcome back to another YouTube live stream and another episode of the ClassE Morning Show. I'm your host, ClassE Beats of ClassEbeats.com. Patreon.com/ClassEbeats, by the way. The link is in the description as well as in the pinned comment in the chat. We've got an amazing show for y'all today. It's going to be a great time. We're going to hear some interesting topics, especially when it comes to Tony Busby. I know. Tony Busby is under fire again. We're going to get into some updates from the TAY trial as well as some other news. But before we do, I got to say what's up to the people, man. And I got to get y'all's comments on the screen because I was disrespecting y'all with the comments, man. Let me see who we got in here. Hold on a second. Nope, that's not it. Nope, that's not it. All right, there we go. I see y'all in here. Shout out to my awesome, amazing Amy is in the building. Shout out to Amy up in here. Who else we got? We've got, let me see. There it is. We got my dog, Les Cleaver, is in the building. Good morning, Les. Good to see you. We got Michi in here. A-Fitz, Kara is back at it. Jay Buckmaster's in the building. We've got Shauna, Trisha. Shout out to you. BSB is up in here as well. We've got Taco Tuesday. Happy Taco Tuesday to y'all, by the way. Hopefully y'all are having a great Taco Tuesday up in here. We've got, who else? Valencia is in the building. Good to see you. Libby22 SC Girl is up in here as well. All right, we're going to go ahead and get right into it. I'm not going to waste any more of y'all's time. I know we're starting a little bit later than we usually do, so I want to go ahead and get y'all the content. But first, I do have to ask a favor. If y'all could, please make sure you like the video on your way in. Not only is it free, not only does it help the show continue to grow, it takes less than 1 second and it lets the algorithm know that you guys are enjoying the show, and it shares the channel and the video out with more people. So if y'all could do that, please do it because we need some help, man. They out here trying to attack us. I actually have some interesting news that I had hinted to y'all about a few months ago when it comes to what was going on here on the YouTube channel. Now, with that being said, I don't want to talk about it here on YouTube. We're going to cover what's been going on with over on the Patreon. So I'm going to do our first ever Patreon exclusive live stream. So if y'all haven't checked out the Patreon, make sure you go over there. I've been dealing with a, we'll call it a lawsuit for now. And we've had some things that have recently changed with the lawsuit. I'm going to give you guys an update, tell you the whole story about what happened, what went on, what's going on here on the channel. And, you know, we're still being under attack for some reason for what we're doing here and the content that we're creating. So with that being said, if y'all want to check that out, make sure you go over to the Patreon. I'll be dropping the video over there, and we'll probably do a little bit of a live stream as well, so y'all can know what's up and what's going on with this, what's happening here on the channel. All right, so we'll get into it shortly. Let's go ahead and get into our first topic. So y'all know we love to roast our guy Tony Busby over here. Shout out to Tony Busby. He is now under fire again when it comes to this lawsuit that Jay-Z filed against him and Jane Doe. So what's happening? So obviously we know Tony Busby and Jane Doe, they went in on this lawsuit together. They said, we're going to go after Jay-Z. Jay-Z disputed the lawsuit. Not only did he do that, he fought against it. He tried to get it to dismiss. The judge said, we're not going to dismiss it. So then more information started to come out. Jane Doe said, hey, I don't want any of this smoke. We'll just let it go. Jane Doe dismisses it. Now Jay-Z is countersuing in a lawsuit against Jane Doe and Tony Busby for defamation. And we've talked about the amount that Jay-Z has lost as a result of this lawsuit. He's alleging it's millions and millions of dollars, which is not going to be good for y'all's guy, Tony Busby. So now what's going on? Tony Busby, and shout out to Cat Not Williams for dropping this over on X as well. Tony Busby, Fortney, and the Busby law firm have filed a motion to dismiss Carter versus Busby. All right. And this was the one that was filed in Alabama, Cat says, where Jane Doe is also named as a defendant. Included, and she's got the affidavit here from David Fortney. What is he saying? The state of Texas, in the county of Harris, Texas, says, before me, the undersigned notary, on this day personally appeared David Fortney, a person whose identity is known to me. After I administered an oath to the affidavit, he testified as follows. Here we go. My name is David Fortney. I am over 21 years old, of sound mind, and capable of making this affidavit. The facts stated in this affidavit are within my personal knowledge and are true and correct. I am a resident of the state and citizen of the state of Texas. I have personal knowledge to the matters forth below because I was personally involved in the events described herein. And because I am an attorney with Anthony G. Busby, Tony Busby, LP, and the Busby Law Firm. I also have personal knowledge because I worked on Mrs. Doe's case during the firm's representation of her. Might be in trouble. At all relevant times alleged in this complaint. I have reviewed and am familiar with the allegations made by Carter in the complaint. Neither I nor Tony Busby nor the firm ever solicited in Alabama or anywhere else to represent Jane Doe. The firm was referred Mrs. Doe's case by the AVA Law Group, which we've heard they've got their own issues going on right now, with whom Doe signed up online. No defendant met with Mrs. Doe in Alabama before the lawsuit alleged in the complaint was filed in the Southern District of New York. This is completely contradictory to what Tony Busby said, because didn't Tony Busby say that they completely vetted her? I got to read this again. No defendant. So he's saying not the Tony Busby law firm, not Tony Busby, not David Fortney, met with Jane Doe in Alabama before the lawsuit alleged in the complaint was filed in the Southern District of New York. Wow. Or before the lawsuit was amended to name Carter specifically. So he said everything was done before they even met with Jane Doe. Is that what we're saying here? This is insane. No defendant met with Mrs. Doe in Alabama before the demand letter referenced in the complaint was drafted or sent. I traveled to Alabama only twice for any purpose related to the facts alleged in the complaint, and each trip took place after the New York lawsuit had been filed, after Carter had been named specifically in the lawsuit, and after the demand letter had been sent. This is so confusing. I first traveled to Alabama after the NBC interview alleged in the complaint. So they didn't talk to her until after Tony Busby met with her for the first time when he met with her in Texas for the NBC interview. Okay. I first traveled to Alabama after the NBC interview alleged in the complaint, and then again before the New York lawsuit was dismissed. On both occasions, I met with my client, Mrs. Doe. Tony Busby never traveled to Alabama for any reason related to Mrs. Doe or the allegations in the complaint. Colby Haller, an associate with the firm, flew to Alabama once to escort Ms. Doe back to Texas after Carter's investigations found her at her residence, as we wanted to provide Mrs. Doe with a measure of security. Yeah, right. Haller's trip to Alabama was after the New York suit had been filed, after Carter had been named in it, and after the demand letter was sent or had been sent. As the complaint notes, Tony Busby first met Mrs. Doe in Houston, not Alabama. Okay. I was present at the meeting. No defendant other than Mrs. Doe resides in Alabama, has an office in Alabama, owns property in Alabama, is licensed to do business or practice law in Alabama, has employees in Alabama, or is involved in any other lawsuits in Alabama as counsel for the party. No court appearances by the defendant for Mrs. Doe ever occurred in Alabama, so that's why they're trying to get this dismissed. No defendant advertised or solicited for clients in Alabama. The demand letter alleged in the complaint was sent from Texas to Reed Smith's attorney for Carter in New York. The letter was not sent to or from anyone in Alabama. The NBC interview alleged in the complaint did not occur in Alabama. That is true. No part of the drafting or filing of the New York lawsuit occurred in Alabama. None of the legal work done by myself, Tony Busby, or the firm ever performed with the intent to affect Carter in Alabama, where he is, per the complaint, not a resident. None of the firm's communications with Carter or his counsel took place in Alabama or were directed to Alabama. Neither I nor Tony Busby nor the firm ever used or invoked the Alabama judicial system in any way related to the plaintiff, Carter, or any other allegations in the complaint. I'm not aware of any other contracts by myself, Tony Busby, or the firm with the state of Alabama related to the allegations of the complaint or Doe beyond those outlined above. So it sounds like what they're trying to say is, hey, remove us from this lawsuit. I mean, obviously they have a motion to dismiss, but are they trying to get themselves removed from this lawsuit? Because if that's the case, then it's going to be fully on Jane Doe because she was in Alabama. So it's interesting that both of these were filed. And I wonder if they're going to amend this lawsuit and only have Jane Doe listed on this, which means she's going to be on her own. Oof. Yikes. And also, shout out to Cat Not Williams for this. She says, as one might guess from the Fortney affidavit, Busby and Fortney's focus heavily on the jurisdiction venue. And we're going to look at just the introduction of this response by Tony Busby and David Fortney. And this is the motion to dismiss. Obviously, Jane Doe is mentioned in this as well. So what are they saying? Let's just read the introduction real quick. Defendants Tony Busby, David Fortney, and Tony Busby Law Firm, collectively the Busby defendants, moved this court to dismiss all claims against them because the court lacks personal jurisdiction, the venue is improper, and when the correct body of law is applied, the complaint fails to state a claim against the Busby defendants upon which relief can be granted. So they don't name Jane Doe. They don't name Jane Doe here because they're saying this is on her. If we're going Alabama, then hey, it's on her. Here we go. The introduction. This case was filed by a celebrity against his assault accuser, whom the plaintiff himself describes as suffering from personal and financial hardship. That is 1000% true. Just go look on YouTube. All the videos have been made and people saying, well, Jay-Z's guilty of something. Even after all this, it's insane. All right. And against her attorneys in retaliation for seeking to utilize the justice system to hold her alleged assailant accountable. And in this case, a California plaintiff has come to Alabama to assert claims against Texas defendants for something that happened in New York. The events giving rise to this litigation began in the fall of 2024 when defendant Jane Doe retained counsel in connection with her allegations that the plaintiff, Sean Corey Carter, better known as world famous performing artist Jay-Z, assaulted her alongside his longtime friend Diddy. In 2000, when Doe was just 13, well, that's allegedly. All right. In October of 2024, Doe, represented by the Busby Law Firm, filed a suit in the United States District Court for the Southern District of New York against Diddy and some of his business interests. The Southern District of New York action is how it's going to be referred to moving forward. Doe could have named Jay-Z in her original complaint, but did not because he wasn't there. Instead, to give Mr. Carter an opportunity to settle the claims. What? How nice of them. Without making them public, Doe, through her attorney, sent a letter to Mr. Carter's attorneys describing the claims and requested a confidential mediation. Instead of accepting Doe's invitation, Jay-Z said, no, we ain't doing that. He's to confidently discuss a settlement of her claims. Mr. Carter chose scorched earth, public harassment, and litigation. Seriously? Are you serious? That is not what happened. On November 18, 2024, Mr. Carter sued the Busby Law Firm and its principal, Mr. Busby, in Mr. Carter's home state of California, alleging that they were extorting him and intentionally causing him emotional distress. And that turned out to be true because none of these things in this lawsuit were true at all. Mr. Carter and his representatives also dispatched hordes of investigators to harass Doe, her friends and family, as well as the Busby Law Firm's current and former employees, clients, and other business contracts, and also try to coerce Busby's defendants, former clients, to sue them. Wow. Mr. Carter's mission was clear: to threaten, harass, intimidate, and financially punish Doe and her attorneys while peddling Mr. Carter's narrative to the media. I think they 1000% should be punished. Absolutely. For bringing up this fake claim, for making all these lies, putting in a legal document, Tony Busby bragging about how he's going to use the court of public opinion and media to make sure that Jay-Z pays. And now they want to act like the victim. Sorry, guys. If you want to go down this road, you're going to get embarrassed. And you were. And I'm glad Jay-Z stood on this. I don't know if I would have done it. I probably would have just written the check and been like, get out of my face. But thankfully we got to see and talk about how messed up the system is, because they tried it and now they're embarrassed. So don't act like you're a victim and saying that you're being threatened because Jay-Z said, I'm not going to let you just make up things about me. Understanding that Mr. Carter has no interest in a private resolution of the claims, Doe amended her complaint in the Southern District of New York action on December 8th of 2024 to add Mr. Carter as a defendant. Over the ensuing days, Mr. Carter's attorney filed so many unprofessional papers with the court that they received the following admonishment from the district judge. Basically, Judge Vargas said, I'm not changing the rules for y'all. Relax. All right. And we remember when she said that. Also admonishing Mr. Carter's counsel and their unacceptable failure to abide by the court's clear rules. Eventually, the relentless pressure that Mr. Carter and his associates placed upon Jane Doe became too much for her. Oh, poor thing. On February 4th, 2025, an agreement to resolve the litigation was reached between Doe and Mr. Carter through their attorneys. I hate how they phrased this. This is crazy. What was the... This is not true, man. Come on. They said an agreement to resolve the litigation was reached between Doe and Mr. Carter. So what was the agreement? Because all we saw was a dismissed lawsuit. Come on now. This is crazy. On February 4th, 2025, an agreement was reached to resolve the litigation between Doe and Mr. Carter through their attorneys, which included the voluntary dismissal of the Southern District of New York action. It seems like that was the only thing. It seems like Jay-Z said, hey, listen, we're going to take this all the way. You're going to get embarrassed and exposed because y'all see the Southern District of New York, as we just talked about in our last video, is not letting y'all run around here anonymously. So she's going to get exposed. Tony, you're going to get exposed even more than you have been already. And we're going to keep going on this. And they say, it's not worth it. We'll let it go. Notwithstanding this agreement, although Mr. Carter describes Doe as suffering from personal and financial hardship and having lost custody of her children, Mr. Carter, a wealthy celebrity, filed this litigation against Doe and her attorneys, the Busby defendants, and continues to threaten, harass, intimidate, and financially punish them. How? How is he financially punishing them? Mr. Carter's conduct is an attempt to diminish the reputation of the Busby defendants, who at all times were seeking to perform their roles as zealous advocates and who at all times were acting with the course and scope of their professional and legal obligations. If that's the case, why was this dismissed with prejudice? I'm not buying it. This case, an attempt by Mr. Carter to punish his accuser, as he should, and silence potential accusers, that's not on him, as well as discourage any attorney who may represent such victims, is precisely the type of retaliatory and bad faith litigation that courts across this country disfavor. Man, David, if y'all don't get up out of here, you are not a victim, sir. Y'all didn't do your due diligence. You misused the system. And then you went out and dismissed this lawsuit with prejudice. Come on, man. Let's not talk about how did he put it? Let's not talk about retaliatory and bad faith litigation when this lady straight up lied throughout the entirety of this lawsuit that went forward, cost Jay-Z money, not only in legal fees, but money based off of his reputation being dragged through the mud by this fake lawsuit. Man, I don't have time for this. I hate this type of stuff when people abuse these legal systems. Y'all let me know what you think about this in the comments and in the chat. Shout out to the gang in here. And thank you to all 300 plus of y'all that are in the building. Oh my goodness. I got to turn these sound effects down. They're kind of loud. Shout out to Talisha, the future law student. Good to see you in here. Kel Bell, the honorable attorney Kel Bell is in here. Always good to see you, Kel Bell. Thank you for stopping by. We got a couple super chats I want to get to as well, and we'll keep the show moving. We've got Kara in here. She does not miss. She said Taco Tuesday. It's time. Good morning, y'all, with the 2-bomb. Good morning, Kara, and thank you for your continued support here on the channel. I always appreciate you showing up and showing love. Yeah, y'all are in the chat like, what is going on? Les Cleaver's going back to work. This channel is too good for the YouTube folks in the office. Rising star in their presence. Thanks, ClassE and Amy. Thank you, Taco Tuesday. It's so nice. We putting in the work over here. Bay on the other side of his mind. This is crazy, man. And to think the last thing he says in this introduction is, oh, it's in bad faith. What is Jay-Z supposed to do? Is he just supposed to say, oh, well, yay, we won, guys, they dismissed it? No. You guys have to be held accountable for how you choose not only to use the law, but to uphold the law. You need to be made an example of. Jay-Z has to show that you just shouldn't be able to go out here and file a lawsuit against someone where they have little to no facts about the situation. It could happen to anybody. It really could. And like I said, we're going to talk about it over on the Patreon. If y'all haven't checked out the Patreon, go do that. I'm going to tell you guys about a situation I got into here on the YouTube channel, and I was fighting for 3+ months with another YouTuber. I know. And people, they want to go out here, they want to abuse the system, they want to flex and just say, oh, well, this is what I feel like what happened. This is what I want to do. So I'm going to go and file some false claims. Happens every single day. I've dealt with it, and I understand Jay-Z pushing back on them too. So yes, they need to be and should be punished. His fake accuser, punish him. When it comes to potential accusers, if it happened, move forward. You do not have the same burden of proof that you do in a criminal case. And the reason this got dismissed and thrown out is because we, with the help of a simple Google search, were able to see that 90 to 100% of everything alleged in this lawsuit did not and could not have happened. It's not that complicated. Please stop with this. Oh, you're going to silence potential accusers. What about the real victims? You need to talk to Jane Doe about that. You need to talk to Tony Busby about the potential accusers, because it's embarrassing to them. Who do they go to? Who can they trust now? That's not on Jay-Z. That's on y'all for messing up. Anyway, let's go ahead and get into our next topic. Y'all know we have been covering the TAY trial, and we're going to see what happened after they read the verdict for TAY, because we got some more information there. As we reported on yesterday, TAY was found guilty on one count. So he's found not guilty on the capital murder charge. He's found guilty on the murder charge. He can get up to, don't quote me, I believe it was 99 years for that. Yeah. So now, once that took place, we're going to have our post-trial hearing, and then we'll be getting into the punishment a little bit later on today. But y'all check this out from Judge Boyd.
And defense, it's my understanding that you are going to be requesting a hearing outside the presence of the jury on the witness's expertise.
Well, Your Honor, before we do that, I guess if I could take up a collateral matter that
Sure.
informs this decision.
Okay.
Before the trial started, maybe several months before the trial started, the state filed a motion advising that they would be asking Your Honor to stack the sentence in this case with the sentence in Fort Worth.
Mhm.
And obviously, that's a matter we will be taking up after the jury's verdict on punishment. But I wanted to make sure that there was no issue with my ability to argue that that motion was in play. In other words, to apprise the jury of the fact that there is petition by the state that whatever sentence is returned in this case be run consecutively.
Well, I don't think that's going to be discussed with the jury because it's not their decision to make.
Yes, Your Honor, but I think that there's some authority that suggests that unlike parole or
Interesting.
matters like that, the jury needs to be aware that the court has the discretionary power to stack the sentences. Because
No,
if I could just, there's a couple of cases I think that
Sure.
maybe call to this point. And I'll read them into the record real fast. The
Judge
first
Boyd is stone
Vargas
cold. I love
versus
it.
State, VARGAS, 252 Southwest 3rd, 876. That's Court of Appeals, 14th District of Houston, 2008. And Halliburton versus State, HALIBURTON, Court of Criminal Appeals, 1979. And in these cases, there's discussion about, in one instance,
well, let me stop you for a moment, counsel. So here's the question. Is any witness going to be called who's going to be able to say to this jury that stacking or not stacking is completely up to the court? If there is not going to be a witness, then we can take up whether in closing argument or however you want to let the jury know that the court it's the court's authority to decide whether a case is run consecutively or concurrently. We can take it up at that point.
right, because I mean, fundamentally, it wouldn't be a witness, it would be a charge to the jury.
Okay, so we can take that up at that point.
But I just didn't, I would like to talk about it in an opening. I won't if we haven't ruled on it yet, but
Yeah.
I think that because the law seems to indicate jurors are entitled to know, I thought it would be best if we could talk about it in an opening, and I wanted to give you.
We can take it up in closing. I think that would probably be best.
Yes, Your Honor, I understand. Just a moment.
Sure.
We can go ahead and proceed with the hearing outside the presence on the fingerprints, Your Honor.
Okay.
All right, here we go.
All right. And so it's the court's understanding this is simply going to be a hearing.
Yep, then we should proceed forward.
All right. So my understanding, this is just specifically a hearing to make a determination on whether or not the witness that the state is calling as, I'm assuming, a fingerprint expert,
Yes, Your Honor.
whether or not they're qualified.
My challenge would be to their qualification, and I would challenge the science of fingerprinting generally under the Daubert-Kelly standard.
All right, let's bring them in. State, call your witness. If you'll take a seat here, please.
All right, here we go. We're going to talk about some fingerprinting. This is going to be interesting.
And if you can raise your right hand for me, please. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand. If you'll put there should be a little clip, a square. If you'll put that on your lapel or somewhere, it's for the court reporter. All right. And Cindy, I am trying to go to your link. And let me see, it may not be working. Just 1 second. All right, have it. Thank you. All right, if you'll state your name and spell your last name for the record, please.
Mia Valdez, last name Valdez.
All right, you may proceed.
What you got for us, Mia?
Ms. Valdez, can you please just tell us what's your occupation
I'm a fingerprint examiner for the Bexar County Sheriff's Office
and how long have you held that position?
for 2 years.
And how do you have to go certain type of training?
Yes,
What type of training is that?
yes, we go through a 2-week course to learn and identify as well as classify fingerprints, and then as well as on-the-job training.
And so you stated 13 years?
2 years.
I'm sorry, 2 years?
2 years.
Okay, 2 years. And this training that you are having on the job, is that every day you come in, is there certain criteria they have to meet, or how do you go about your daily duties?
We typically review the fingerprints of every inmate that is brought into the jail.
So numerous.
Correct.
And have you ever testified in Bexar County before
Yes, sir.
associated with fingerprints?
Yes, sir.
And what is a fingerprint?
A fingerprint is an impression made up of characteristics that is used for a means of identification for an individual.
And can you describe what an inked print means?
An ink print is typically used with an ink pad as well as an ink print card that is also an impression.
So what's their issue with
of a
fingerprinting?
means to identify an individual.
And these unique characteristics, through your training and experience, have you ever come across or known of anybody having the exact same fingerprint?
No, not in my experience.
And so when you say unique characteristics, does that mean fingerprints are unique and identifying for every individual?
That is correct.
And is this something that's accepted across your line of expertise as an examiner?
Correct.
And can you just describe briefly the different characteristics of a fingerprint?
Oh, so typically they have 12 different characteristics consisting of ridge endings, bifurcations, island ridges, and other multiple characteristics to identify the fingerprint.
And again, this field of fingerprint examination is an accepted practice.
Correct.
We'll pass a witness, John.
May I proceed?
Yes.
Thank you, Your Honor. Good afternoon, ma'am. How are you?
Great. How about yourself?
I'm well, thank you. So in terms of what you have been called here today to do, were you asked to give an opinion about comparison of fingerprints?
Not an opinion, so per se, but yes, to identify fingerprints.
Okay, now, when you say not an opinion, you were asked to look at some inked fingerprints that you did of Mr. McIntyre here in this courtroom about 15 minutes ago, right?
Correct.
And you were also asked to look at what I imagine was a drop card that had been taken on a previous date.
Correct.
Interesting.
And, that drop card, did it contain any information on it, or was it just the fingerprints?
No, it is a part of the booking sheet, so it had name, date of birth, and other identifiers.
So it was a booking sheet,
Correct.
was not a judgment.
I was reviewing judgments, but there was also a booking sheet.
Well, did you compare it to booking sheet or to the judgment?
Both.
You compared it to both a booking sheet and a judgment.
Correct.
Okay. And those things obviously had a name on it.
Correct.
Associated with both the judgment and the booking sheet.
Correct.
I guess it was the same name.
Yes.
I gather you're going to testify that name was Tamor McIntyre.
Correct.
And you believe that that's the same individual that you just took prints of
That is
today,
correct.
correct?
So what's the issue with the
So,
prints though?
To be fair, you were
Help us out, John.
not given anyone else's fingerprints to compare it to, right?
No, sir.
And you are aware of why you're here and what you were called up today to do, right?
Correct.
You're aware of this trial generally.
Correct.
And so the prosecutor was asking you this specific question in the context of being able to prove up a prior judgment for sentencing.
Correct.
And you have not given the work that you did in this case over to any other examiner to see if they could check your work.
No, sir.
And that's not a common practice that's done by your department in these kinds of situations with inked prints, correct?
Correct.
Now, you talk about the unique characteristics of an individual that appear on their fingertips that would leave these telltale markings, right?
Correct.
Do you know what scientific work has been done to confirm whether or not that is a universal truth about the human condition, that every single human being alive has genuinely a completely different fingerprint?
That is not a part of my department to research that.
Okay. Do you know whether or not there's been any scientific research done to determine whether people's fingerprints change over time?
Definitely, sir.
Okay. Do you keep up with any literature in the field discussing potential
We're
problematic
questioning the
areas in
science of
fingerprinting or
fingerprinting.
places where a fingerprint
Interesting.
examiner might make an error?
Yes, sir. I have.
Okay. And are you aware that errors can be made in fingerprint examination?
Yes, sir.
Can you talk to the judge a little bit about the ways that you've been trained to look out for errors and mistakes?
In terms of mistakes, there is multiple reasons. It could be unable to read a fingerprint due to scarring, burning, or anything of that matter. We also encounter amputees to where we don't have a fingerprint to discover. And then as it changes
Wow.
over time, it does become a little bit more difficult to read the fingerprint.
When you say as it changes over time, you mean as a person gets
Sorry,
older?
yeah.
Correct.
So fingerprints that were taken when someone was 17, 18 years old may be different than they are when they're 25.
No, not necessarily. It has to be like a wide age gap.
Okay. Say not necessarily. I mean,
Sorry,
you can't
yeah.
speak specifically to how many years it is before someone's fingerprints might show different characteristics.
Not a specific number, no.
Okay. And admittedly, what you're doing here is you're looking at the exemplar print and you're looking at the print that you're asked to compare that to. And you're eyeballing visual characteristics of how the ink appears on the paper, right?
Yes, sir.
And did you make any drawings or rough notes or sketches
No,
to
sir.
document that?
No, sir. I just fingerprinted.
Okay, so it's just something that's in your head based upon what you saw with your eyes.
Correct.
And so even if we had another fingerprint examiner here today to try and check your work, they wouldn't really know exactly what were the things that you keyed in on.
Correct.
They'd have to make
They
their own
did, yes.
independent evaluation.
Yes, sir.
Do you know of any other scientific discipline where the answer to your question has been predetermined in advance by the people asking it of you?
No, sir.
I'll pass the witness.
Any further questions?
No more questions. Your Honor.
All right, the court will hear argument.
Your Honor, I think that we don't have the Daubert-Kelly standard satisfied here. This is something that was done here in the last 15 minutes. There's been no attempt to check the work, to have it peer reviewed, to have it assessed by anyone else. The witness is not fully familiar with all of the literature about the potential pitfalls of comparison. The witness does not have any documented example of the work that was done by the visual examination conducted here in the courtroom today. So there will be no way to independently criticize that work or vet it, because the next person we bring in would just themselves have to do the exact same visual eyeball observation. So what we're doing here is we're asking someone who has a 2-week course on identification that talks about the basics.
Dang, taking
years of
shots.
on-the-job experience, looking at print that they've been told in advance is likely belonging to the same man that was fingerprinted in the courtroom, and giving a confirmatory example. That's not a scientific pursuit, although it is a question that touches upon scientific evidence. And we know, both from popular culture and from just the way that we verbally discuss the concept of a fingerprint, that people do place undue emphasis on what a fingerprint.
So
can
you're
tell you.
saying that the state told her that this is the person and this is their fingerprints?
I think that was the witness's testimony.
No, I'm just saying, is that what you're saying?
I believe that's what the witness testified.
Okay, all right.
I think that that is definitionally unscientific, and that it should not be admitted under Rule 702 or Daubert and Kelly, that does have inherently a due process component to it. And so we would object to the testimony.
All right, state response. He said that you told the witness who the fingerprints belong to.
Your Honor, no. We asked her to compare the person that she had fingerprinted today with a fingerprint, and she did that, and she identified that it was the same person that she just fingerprinted in court. The underlying validity of this technique has been applied properly, and she has the experience and the training to be an certified, a fingerprint examiner. So the state's position is, one, in a sense, defense is saying that the state has asked somebody to lie on the stand, and I take offense to that.
That is not what we're saying, Jason.
That's not what he's saying.
In a backdoor way, Judge, that's what he's saying, so I don't
It's not even
appreciate
in a
that.
backdoor way. No, that's not what we're saying.
All right, so here's the thing. We cannot speak over each other. I'll let the state finish, and then defense, I'll allow you to respond.
So Judge, and another premise that we asked an individual to come up on the stand and identify somebody
Thank you, Amy.
just for the reasoning of having a fingerprint match. The state is not in that, would never put themselves in that position due to ethics and also following an oath that has been taken. So in this particular case, Your Honor, the state simply asked Mia Valdez, a fingerprint examiner for Bexar County Sheriff's Office, to see if she could identify a fingerprint that she identified the person that she took fingerprints in today, and then compared that to a judgment and identified that person as stay more back in time.
All right, now your response.
Your Honor, the testimony of the witness was that she was presented a booking sheet and a judgment. Now, perhaps the witness has those documents in front of her and would produce them as court exhibits so that we can clear this up. But my understanding of the words booking sheet and judgment are that those documents contain the name of the defendant. The witness also testified that they are aware of this case and who is being prosecuted and what this case is about generally.
So you're not saying that the state told her that this judgment is for your client?
What I'm saying is the state gave her documents that contain identifying information on them. And
Right,
asked them to.
But I just want to be clear, because I need to make a ruling. So you're not saying that the state gave her a packet, gave her documentation and says, we're giving you this documentation. It goes with your client. So bring us this information.
I am not accusing Mr. Garahan or anybody else in the district attorney's office of telling the witness what to say
Okay.
or violating in any way their ethical obligations. And I'm so sorry that you perceive it that way. I can't fathom that that's how you perceive it, but I'm sorry. My purpose in making the argument is the witness has testified that they review judgments and booking sheets. I've never seen a judgment or a booking sheet ever that don't have the name of the defendant on them.
Mhm.
And the witness also attested to the fact that they know who Mr. McIntyre is, or at least they testified they're aware who's on trial here, which
Okay.
would give them the name of them. So, I mean, it doesn't have to be that someone went in there and said, now listen here, I need you to testify that that man there is Tamor McIntyre. And he's the same man that's on this drop sheet.
Okay, so I understand your argument. So the defense's motion is denied. The witness will be allowed to testify. With regards to opening statements, you are allowed to let the jury know that the court makes the decision on whether sentences run consecutively or concurrently.
Yes, this was
The
after
end.
the verdict.
Thank you, Judge.
All right, so if you can step down from the witness stand, I'm going to bring the jury in. And let me ask you all, does anybody have let me see if I have a copy of the indictment. I don't know, is there an enhancement in the indictment or no? So it's strictly from motions.
It's strictly a motion to stack the sentences from the state.
Okay. And I'm assuming that your client is not pleading true to the prior.
Well, Your Honor, it's not, it isn't alleged in the indictment and it isn't being used as an enhancement because it wasn't a final
No,
conviction.
no, I understand that.
Right.
But I'm asking, is the witness going to come and testify, or is your client planning on saying that he is in fact the person who has this prior judgment or no?
We are not going to plead true.
Okay, that was my question.
Sorry,
All right,
I'm sorry, but we're not pleading true.
okay.
Witness took the mic. Is she the first witness?
Yes, she's the first witness. Nobody read your sign that said, "Do not take the mics." All right, to the advocate, can you make sure that the witness still has the mic and not to lose the court reporter's mic?
Okay, good.
Thank you.
We're going to skip ahead here a little bit.
Phase of this trial,
Here we go.
second phase of this trial. Each party will have a chance to give you their opening statements for this phase of the trial if they choose to do so. State, are you prepared to proceed?
Yes, Your Honor.
All right, you may proceed.
We'll waive our opening, Your Honor.
All right, defense.
Thank you, Your Honor. May it please the court, opposing counsel, ladies and gentlemen. Again, I want to thank you all very much. Obviously, at this point, it's clear that there are some things that we disagree about. That's okay. Also clear that there are some things we do agree on. I'm glad to be on that same page with you as we proceed following. We're here to decide the appropriate punishment. And that's an extremely difficult decision. That might be the most difficult part of any homicide case. The state is going to tell you about Mr. McIntyre's past criminal history and about things that were going on while this case that you all have heard was developing. You're going to hear about Mr. McIntyre's pending case for a murder charge in Fort Worth, where he was found guilty and he was punished for it as an accessory to the crime, as part, not as the man who pulled the trigger, not as someone who was the direct and proximate cause of someone else's death.
Oh, y'all
That
think
is a
they knew?
participant in that criminal activity, much like you were charged in the law of parties in this case. You're going to hear evidence.
wonder
that
if they
Mr.
knew.
McIntyre was on bond for that case when that happened. You're also going to hear evidence Tamor McIntyre was 16 years old when this happened. He was a child. You're going to hear evidence that Tamor's childhood up to that point was far from idyllic. He was in the foster system with his sister. He was brought back to live with his father, who was extremely physically abusive to him, breaking bones, breaking ribs. He had to run away and go live with his sister in Corpus. You're going to hear about how that affects him and how it impacts his judgments. We need to always remember as we go through the evidence of this portion of the trial that we are looking at this whole circumstance through the eyes of a 16-year-old boy who has had a traumatic, horrible life and whose judgment was impaired. You heard testimony in the guilt innocence phase about the fact that Mr. McIntyre had consumed LSD the night before. And while a lot of time had passed before the incident that you all considered in guilt innocence took place, we have to acknowledge that there are impacts on his perception of this situation. Now, we talked in jury selection. Intoxication is not an excuse. Intoxication is not a reason why someone should not be held criminally responsible. But it is absolutely something that you all should be considering when you're deciding what is the appropriate punishment. The punishment range for first-degree murder in Texas is anywhere from 5 to 99 years or life in prison.
There it is.
And
99 years
that's
is
a
crazy.
huge range of time.
Mm-hmm.
And we understand, I think, that not all murders are created equal. While we go through this, I ask that you all have some patience with me and bear with me. Because while I know that we all agree on one central thing, which is that there was not enough evidence to convict Mr. McIntyre of capital murder, there was not enough evidence that Mr. McIntyre robbed anyone, we certainly have differences of opinion about different aspects of this case, which I'm going to do my very best to respect. But I don't know exactly why each of you made the decision that you made in the guilt innocence phase. Some of you may have made it for different reasons. You only need to be unanimous about the ultimate conclusion. So there are things that I'm going to talk about that you may think, well, that's him talking about self-defense. And I've already heard that, and I don't believe it's self-defense. And come on, like, stop talking about self-defense. But remember, just because someone isn't 100% in the right doesn't mean the other person isn't partially in the wrong. And we have to acknowledge that every human interaction is a two-sided coin, and that there are aspects about Mr. McIntyre's perception on the world, his understanding of what was going on, the events that led up to being in that car with Mark, that have bearing on how responsible he should truly be in the grand scheme of things. Those are things that I ask you all to still consider, even though I gather you all have rejected the idea that what was done was justifiable by self-defense or otherwise. Keep those things in mind. Also keep in consideration things that relate to how Joanna behaved in all of this. While I
Joanna was
understand that you
garbage.
all found Joanna credible enough to accept her testimony for the purposes of overcoming the accomplice witness rule, and I can understand y'all's reasoning there, please also understand there are significant reasons why we should be suspect of Ms. Reyes's testimony. And those
I
reasons
agree.
have additional bearing into how you should make the decision to punish. Remember, Mr. McIntyre was 16 years old when this happened, but Ms. Reyes was 19 years old. Jeremiah was 19 years old. Mark was older than him.
Where's Jeremiah?
Jalen was the closest to
Where's
Still
Jeremiah?
older than him. Tamor is the youngest person in that car. And Tamor is now here in front of you, asking you all to decide how to punish him for this horrible, tragic thing. And keeping that aspect in mind, the motives of the other people, why things were done the way they were, all should be brought to bear, right? The fact that his presumption of innocence has ended does not mean that you all cannot continue to give some credence to the fact that Mr. McIntyre is, like all of you, a human being, and he deserves to have dignity in the way that his punishment is considered. And I want you all to think about some things that are surrounding the circumstances of this case. Because what we're here to talk about is not going to bring Mark back. It is not going to right any of the wrongs that you all have passed judgment about guilt and innocence on. Those things are not fixable. No matter what we were to do, we can't take back time. We can't take back these decisions. We are all having to move forward. And I would submit to you that the criminal justice system and the way that we handle carceral punishment of people, locking people away, is just one idea out of many in how we address these otherwise unsolvable problems. It is good for the human heart. It's cathartic to try and see that someone is being punished for what they've done. And I understand that. And there's nothing wrong with that desire that we all feel, all experience, when we have identified that someone has done something that offends the values of society and that puts us in danger. And I respect that. But we have to also understand that it doesn't do any good to solve one wrong by committing another. And I would submit to you that because you will be asked to consider a wide range of punishment, and I would expect that what will be sought from the state of Texas on your behalf as the punishment will be an exceedingly long term of years, to remember that there might be other ways to address problems in society than warehousing human beings. James Joyce, the Irish author, once famously said that Ireland was like a sow that ate her own piglets. And I worry sometimes that in America, that's what we have. We have children who are trapped in the foster system, children who are the victims of abusive parents, of parents with substance abuse problems, children who don't have any chance of having a proper moral compass, a proper guiding system. They have to figure those things out for their own. And unfortunately, they have to do that by trying to live in an adult world as a child. That's a pretty impossible ask. And yet we do it. And we arrest them. We certify them as adults. And we take them to trial. We send them to prison for the rest of their life. The world just keeps on turning. Folks, I just don't see that as being a sustainable model. It doesn't make anything better. Doesn't make anyone better. A little kindness, a little compassion, even in the face of something that we can all agree is evil, wrong, not acceptable, is always the better road to take. At the end of this, you will be asked to make that decision. We can't walk it for you. It's going to be personal to each and every one. All we ask is that you hear the evidence, that you understand we're not trying to paint this boy as a saint. And I'm not asking you to forgive him for what he did. I'm just asking you to keep it all in perspective. I understand that while it's easy to say, you did something evil, we're going to throw you away. As the prosecutor said in the closing argument, if Tamor treated this boy as a piece of trash, then the implication should be that you should treat him as a piece of trash. Isn't always
Dang.
the answer. Yes, the Bible talks about eye for an eye, but that's the Old Testament. And there is good news. And it's to turn the other cheek. I'd ask you all to keep these things.
Oh,
in
he
mind.
preaching up in here. I see you, John.
Thank you all for your deliberation and your patience with the sentence.
Talking about the word.
All right, state, call your first witness.
Yes, Your Honor, the state calls Mia Valdez.
Who is Mia Valdez? Y'all know who she is. John was up in there preaching.
If you can raise your right hand, do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand if you'll state your name for the record and spell your last name, please.
Mia Valdez, last name Valdez.
All right, state, you may proceed.
Thank you, Your Honor. Ms. Valdez, can you please tell the jury what's your occupation?
I'm a fingerprint examiner for the Bexar County Sheriff's Office
And how long have you been an examiner there?
for 2 years.
And did you go through a certain training to become an examiner?
Yes, sir. I went through a
A
2-week
two-week-
course for
a
identifying
two-week
and
training.
classifying fingerprints as well as on-the-job training.
And have you
John was
testified
cooking her
for
for
the
that.
training before?
Yes, sir.
And why don't you describe to the jury just what a fingerprint is?
Fingerprint is an impression of consisting of characteristics that help identify an individual.
And what about an inked print?
Inkprint is the same thing, is used with ink pad and an inkprint card used for impressions of characteristics to identify an individual.
And so on these ink prints, are you able to compare ink prints with other ink prints? And can you please just describe to the jury how that is done?
Usually we use 12 set of characteristics to identify an individual using multiple methods, and then we're able to point out ridges and stuff like that for the identification.
And are you able to compare, well, one, are there unique characteristics to every fingerprint?
Yes, sir.
And are any two fingerprints, have you come across or known about any two fingerprints being the same?
No, not in my experience.
And I'm going to show you what's marked state exhibit number P1. Please tell me, tell the jury, one, can you identify that?
Yes, this is an inkprint card.
And can you describe to them what a print card?
Inkprint card.
Ink print card. Can you describe to the jury what that is?
It is a card that has the impressions of the fingerprint using an ink pad.
And do you recognize this particular ink print card?
Yes, sir.
And how do you recognize it to be?
I was the one who was taking these fingerprints.
And the individual that you took those ink prints from, is that individual in the courtroom?
Yes, sir.
Can you please just point him out and identify an article of clothing he's wearing?
It's the gentleman in the gray sweater.
Now, did you have an opportunity to compare? an ink
Stop
print
snitching,
to
Valdez.
another
she's not
print,
snitching, boy.
on a judgment?
Yes, sir.
I'm going to show you what's been marked. State exhibit number P2. Can you tell me if you recognize that document?
Yes, sir.
And tell me how you recognize that document?
This was the judgment that I reviewed.
And is there a print in that packet?
Yes, sir.
And were you able to compare that print with the known ink prints that you took in the courtroom today from Mr. McIntyre?
Yes, sir.
And did you come to determination if those ink prints match on those documents?
Yes, sir. They were a match.
And do you remember which fingerprint that was?
This one was going to be the right thumbprint.
And on that, well, one, the state would offer state exhibit number P2 and evidence, Your Honor. At this time, we'll tender to the court for any objections.
No new objection.
All right, then states exhibits P1 and P2 are admitted.
Now, particularly on state exhibit number P2, the named individual as the defendant on this, who is that?
That would be McIntyre Tamlin.
And then also, under the actual charge, what was the charge of the offense?
This was going to be for murder.
And what was the offense date?
There you go.
Offense date of 7/26/2016.
So July 26, 2016.
Correct.
And then also on here, what is the plea to the offense?
Not guilty.
And what is the verdict of the jury?
Guilty.
And was there a time assessed?
Yes, sir.
And what was that?
55 years. Sorry.
55 years?
Correct.
That was the
I'll
first
That
charge.
was under, is that a count one?
Correct.
And under count two, is that also an offense named in that?
Correct.
And what is that offense?
Aggravated robbery with a deadly weapon.
And deadly weapon to it, what?
To it, a firearm.
And what was the plea by the defendant?
Not guilty.
And what was the verdict of the jury?
This one was guilty.
And what was the punishment assessed?
This one is for 30 years.
Count three. What was the offense,
Crazy.
The defendant was convicted of?
Aggravated robbery with a deadly weapon, to wit, a firearm.
And in this particular case, what was the plea?
Guilty.
And then what was the years assessed?
13 years.
For count four. What was the offense which the defendant was convicted?
Aggravated robbery with a deadly weapon, to wit, a firearm.
And what was the plea to that offense?
Guilty.
And what was the punishment assessed?
13 years.
Come on, prosecutor. I'll have us falling asleep over here.
Show you when it starts. P4. Can you look over that and tell me if you recognize that?
Yes, sir.
And looking at this document, is there any identifying numbers on there?
Yes, sir.
And also a name
Correct.
and also a date of birth?
Correct.
And does the SID identifier match the SID identifier on the judgment?
That's correct.
And do you know this to be a booking photo?
Correct.
Judge, at this time, the state would, oh, I'm sorry. What is the identifying number of SID?
Send me the state ID number.
Can you call that out, please?
Stands for state ID number.
164-60189.
And on state exhibit number P4, does that match that SID number on that document?
That is correct.
At this time, Your Honor, the state would move into evidence P4, will tend to defense for any objections.
No new objections.
All right, states exhibit P4 is admitted.
Thank you, Judge. May I just publish to the jury?
Yes.
And this is what was identified as P4, and those are booking photos of this individual when he was booked in Tarrant County.
Correct.
Thank you. And again, he was convicted of 1 murder and 3 ag robberies.
Correct.
Thank you. We'll pass the witness.
All right. Defense, you may proceed.
Thank you, Your Honor. One and two right there.
Do you have your microphone?
So sorry, I just walked off. Work okay. I'm going to show you what has been admitted as states 2. This was the document that Mr. Gareham was just going over with you, right?
Correct.
And you indicated that it's and more Trayvon McIntyre.
Correct.
and it's out of Tarrant County, correct?
What's up, Gail?
And
Good to see
here,
you.
I want to call your attention to this portion here. What does the judgment say? Right there.
The sentence shall run concurrently.
Thank you. Pass the witness.
That's
No
it.
further question for this witness.
All right, is this witness excused or
There's
subject
the
to recall?
fingerprints. That's it.
Excused by the state, Your Honor.
Excused by the defense.
All right. The rule has been invoked. You're not allowed to discuss your testimony with anyone during the pendency of the trial. All right, if you'll leave the microphone behind. State, call your next witness.
Good job, Miss Valdez.
Rodriguez.
Mr. Brown's doing great. Mac, he's just in here earlier.
Right, if you can raise your right hand. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am, I do.
All right, you can lower your hand. Make sure you put the microphone on, please. And if you could state your name and spell your last name for the jury.
My name is Anthony Rodriguez. I spelled ANTHONYRODRIGUEZ.
All right, state, you may proceed.
Sergeant Rodriguez, how are you currently employed?
I'm an investigator with the Bexar County District Attorney's Office. I hold the rank of sergeant. I'm a criminal investigator.
And how long have you been with the Bexar County District Attorney's Office?
I'm just over 12 years. February was my anniversary date.
Okay. Before becoming
Happy
employed with the
anniversary.
Bexar County District Attorney's Office, where did you work?
I spent 12 years with the Bexar County Sheriff's Office prior to coming here to the DA's office.
Okay. And when you worked with the Bexar County Sheriff's Office, what was your title or assignment?
For 10 years, I was the gang intelligence officer for Bexar County.
Okay. And did you specifically undergo any training regarding recognition of criminal street gangs?
Your Honor, can we approach?
Yes.
Uh-oh. TAY, a unknown gang member? Is that what we're getting into? Interesting.
Is a witness. All right, so let me check. And, all right, everyone, please be seated. And my understanding is the witness is going to testify to potential gang affiliation or something of that nature.
That's correct, Your Honor.
All right, so I'm gonna let the state ask their questions so I can see where this is going, and then I can hear objections and see whether there's a need for a hearing on expertise.
Thank you.
Yeah, we didn't talk about this throughout the trial.
Sergeant Rodriguez, so you said that during the Bexar County Sheriff's Office, you spent 10 years doing what?
I was the gang intelligence officer at the Bexar County Sheriff's Office.
Okay. And regarding any training and experience that you have, can you just briefly go over that to the court?
Yes, I'm a member of the Texas Gang Investigators Association, also the International Latino Gang Investigators Association.
Oh, nice.
I have received training through the Texas Commission.
Y'all have dim the lights. Thank you. All right, I'm gonna continue.
You have additional training through where?
Through the Texas Commission on Law Enforcement Standards and Education, otherwise known as TCO. But the primary form of my training was on the job training, interviewing gang members over those 10-year period, learning about the gangs from the gang members themselves.
Okay. And so I guess while you were employed with the Bexar County Sheriff's Office, did you spend some time in classification?
Yes, ma'am. So my primary job location was at the classification section. My primary duties were to house inmates, gang members specifically.
Okay. And so as a part of being a classification deputy, did you routinely conduct interviews with documented gang members?
And undocumented, yes, ma'am.
Okay. And do you have any other additional training regarding the recognition of criminal?
What's a
street gangs?
documented gang member look like?
Outside of what I just mentioned, no, ma'am.
Okay. And as part of your current employment, do you keep updated with any literature or training materials regarding gang identification?
Yes, ma'am. So I'm still an active member with the Texas Gang Investigators Association. I am also a liaison to the Texas Anti-Gang Center. I administer all the gang documentation here in the Bexar County DA's office. And I routinely consult for the office as a gang expert.
Okay. Now regarding how you're able to identify defendants as members of criminal street gangs, can you kind of just go over the different ways you would be able to identify someone as a member of a criminal street gang?
Yes, ma'am. So Texas has a central gang database that's legislative. It's required by the law. We refer to that database as text gang. That database requires all law enforcement agencies that are in a jurisdiction over a certain population
just
to
thinking
report
about
all gang
Viverito,
data
too.
to that central database. Text gang is what I check to see if this individual has ever been identified as a gang member. Outside of that, check to see if he ever been incarcerated in any other jurisdictions or agencies. Therefore, I can check to make sure if they've ever documented him. It may or may not have been a text gang. Text gang has a lot of rules. One of the rules is that after so many years, it'll drop off the system. So if an individual's been documented, 5 years have passed, it could get dropped off.
Okay. But just regarding incarceration specifically, are you able to reach out to other, county jails or incarceration facilities and obtain documents that are kept in the regular course of business for them when they are classifying and housing defendants in their jail?
Yes, ma'am, I can.
Okay, and did you do that in this case?
Yes, I did.
Okay, and did you review the materials that were sent back regarding this defendant?
Yes, ma'am, I did.
Okay, and then did you form an opinion as to, well, if I could just, Judge, do you want me to just go over everything or just the qualifications for?
The qualifications and then how that is attached to the defendant, if something is attached to the defendant.
Okay,
Any underlying facts and data we'd like disclosed. The witness relied on it and bring his opinion.
well, they've been filed under business records affidavit. I can get you a copy if you'd like.
And I think we have a right to have the witness proffered to the court for the review.
All right,
under
so this is
705.
what the court is going to say. I just want to know from this witness, his level of expertise, how is it related to this specific case in this defendant?
Yes.
And I think you can pass for.
All right. Now, regarding the defendant, Tamar McIntyre, did you gain knowledge that he was incarcerated in the Tarrant County Jail previously to being incarcerated in the Bear County Jail?
Yes, I did.
Okay, and did you reach out to Tarrant County and obtain records regarding his classification in the Tarrant County Jail? Did you obtain those records that were regularly kept in the course of business up there?
Objection, this isn't the witness who could attest to what's regularly kept in the course of business in Tarrant County.
All right, that objection's on the wall.
Did you obtain the documents from Tarrant County?
Yes, ma'am, I did.
And did they come with a business records affidavit?
Yes, ma'am, they did.
And you reviewed that?
Yes, ma'am, I did.
Okay, thank you. And after reviewing those records, were you able to form an opinion as to whether the defendant was ever affiliated with a criminal street gang?
Yes, ma'am, I did.
Okay, and what gang was that?
He's a member of a Crip gang, otherwise known as the Long Beach Insane Crips.
Okay, and was that determined through a self-identification or what means?
It was determined from a self-identification gang acknowledgement form obtained by Tarrant County.
Okay, and can you just explain to the court what that form is?
So this is a correctional form. It's used in jails and detention. It's used primarily to house individuals. So when somebody comes into a facility, they are approached by what we call a classification officer. This is an individual that houses people in the jail. They're asked a series of questions. One of those questions is going to be, are you a gang member? Many individuals will admit gang affiliation at this time, so they are housed appropriately. They don't want to be housed with rival gangs or things of that nature.
Okay, and do you have knowledge about the Crips criminal street gang?
Yes,
So he was
Okay.
a Crip?
And
Dang.
based on your knowledge of that gang, do you have an opinion as to the purpose of that gang?
it is a criminal organization. It's a group of individuals that are together for the purpose of committing criminal activities.
Okay, and in your training and experience, what type of criminal activities would those be?
They range everything from narcotics all the way up to murder.
Hmm.
So we pass the witness, Your Honor.
Thank you, Judge. Good afternoon, sir. How are you?
Excellent, sir. Yourself?
I'm doing all right. You indicated that you checked databases to see whether or not Mr. McIntyre was listed as being affiliated with a gang, right?
Yes, sir, I did.
And you mentioned text gang is a statutorily required, statewide database about gang affiliation in prisons.
Yeah, no, not in prisons, jails. Well, by law enforcement, not exclusive to just jail.
Okay, just so it could be people on the streets, people in jails, people in prisons.
Not prisons, everything but prisons. I checked a separate database for that.
Okay. Are you aware that many gangs have different organizational structures for people who are incarcerated versus people who are out on the street?
I'm gonna
Yep.
object as well,
How is that
outside of the scope of this
relevant?
hearing.
It goes directly to his qualification.
All right, so. I will hear objection.
I hate gang experts, man.
All right, now you can answer.
No, I don't hate
Repeat the
gang
question, sir.
experts.
You're aware that oftentimes.
These gang
when we
experts
talk
are
about a
always
criminal
interesting.
Gang, that gang may have people on the outside and it may have people on the inside. They often have different organizational structures, right?
That's possible, yes, sir.
Okay. And was it, just so we're clear, was it Tex Gang that you consulted that actually said Tamar McIntyre is a member of this particular gang?
Yes,
Okay, so it wasn't an independent document from Tarrant County, or it was a document from Tarrant County in Tex Gang? Can you just explain
sure,
your method of determining this a little bit more clearly?
sure. Tex gang has a 5-year requirement,
You
meaning
talk to
that if
Vinny.
you're in the system for 5 years and you're not validated, meaning that another law enforcement agency hasn't added to Tex gang, you are dropped off the system. So McIntyre
It's
was
an
in
interesting
Tex gang
system.
from a earlier admission. He had since dropped off Tex gang. However, Tex gang still showed that at one point an entry was made. So to answer your question, I had to do both. The first thing was I acknowledged that there was an initial entry in Tex gang, but to validate that initial entry to ensure that it is in fact the defendant, I reached out to the county that entered that information, and that county is Tarrant County.
Okay, so to be clear, if we were to go look him
Now
up right
he's on the
now, Mr.
chain gang.
McIntyre is not
Mhm.
in Tex Gang
He had since dropped off Tex gang, yes, sir.
5 years ago.
After 5 years. So the original entry date, I believe, was 2017.
Okay, I see. Gotcha. So what? Three years ago,
Yes, sir.
something like that.
Yes, sir.
Okay.
So at the time, he was
mentioned
still in
That
the gang based on their
Long Beach
system.
Insane Crips is a criminal enterprise, basically. Is that your
It's a
testimony?
weird
The
system.
Crips gang is a criminal organization, yes, sir.
Okay, when you say the Crips gang, you understand that there are lots of different subsets of what you call Crips, right?
Yes, sir, there is.
And that many of them have no affiliation with each other whatsoever, right?
That's true, yes, sir.
In fact, some criminal elements that would call themselves Crips are actually fighting each other, right?
That's true.
So we can't say that it's just Crips, therefore it's a criminal enterprise, correct?
Are you talking about this particular gang or all gangs?
I'll withdraw that question. Let me ask you more specifically. Have you ever investigated, other than Mr. McIntyre, any other individual person who's a member of the Long Beach Insane Crips?
No, sir, I have not.
Have you ever encountered anyone
Great question.
who's a former gang member from the Long Beach Insane Crips?
No, sir, I have not.
Do you know anything about the organizational structure of that entity, the Long Beach Insane Crips?
I have some knowledge of it, yes, sir.
Okay, when you say you have some knowledge of it, is it based upon your own investigative work?
Yes, sir.
Okay, but you indicated you never investigated anybody associated with that gang, so help me understand.
I never investigated a person associated with that gang, but I have looked into the gang.
Okay, when you say you've looked into the
He
gang, you
looked
talking
into-
about Google or
he
talking about
looked
something more?
Oh, sure. So we get reading material that's nationwide.
He said,
primarily
you said
from
Google?
The International Latino Gang
Oh, that's
Investigation Association,
messed
also
up.
from the Regional Organized Crime Investigation
Come on,
Center
John.
that provides reading material from various law enforcement agencies throughout the country. This particular gang, the one you're asking about, sir, is a California-based Southern gang. So when I learned of this particular group, I went to that reading material from the southern part of California.
He
There I
said
was
you
able
use
to
Google or
learn a little bit more about this gang.
Okay, well, I mean, so for example, my guess is you have more dealings with some of the Latino gangs here in San Antonio, right? There are quite a few of them in the jails here.
that's a racist
Yes, sir, there are.
question.
Okay, so for example, you know that what is going on in Los Angeles with a gang like the Latin Kings isn't necessarily reflective of what anyone who calls themselves that in San Antonio is doing. You understand that happens a lot, right?
I mean, it's kind of a broad question there, sir. There could be some takeaways
Is
from
it?
incidents in one state that carries over to incidents in this state.
But oftentimes there's no similarity, right? There are plenty of gangs who don't do the same things or have the same structure in one state versus another. Do you agree?
I cannot agree with that, sir, no.
Okay, you think that all people who affiliate with the gang in every single state where they might be locked up all are working under a common objective?
That's why it's called an organized criminal gang, sir. They have an organized structure, they have rank, they have written constitution and
John's
manifestos
cooking
that
for no
allows
reason.
them to remain a structured, organized group,
Okay.
regardless of the state or the location.
Do you have the manifesto of the Long Beach Insane Crips?
I do not, sir.
Do you have any
course not.
idea who's the leader of the Long Beach Insane Crips?
No, sir, I do not.
Do you know who's the sergeant at arms for that?
These gang
organization?
experts,
No, sir, I do
man.
not.
Do you know if they even have a sergeant at arms?
I'm sure they do, sir.
You sure they do, but do you know if that's what he's called?
No, sir.
He's sure they do,
So,
but he don't
You
know.
don't know anything about the structure of the gang, right?
I have some knowledge about it, sir.
Okay, you read a publication from someone in Southern California.
Yes, sir.
Who authored that publication?
I don't know, sir.
Jeez.
You understand that
Get this
when people
guy
get
outta here.
classified, there are often reasons other than organized criminal activity why they might want to be associated with a particular group of people, right?
No, sir, I do not.
Okay, well, do you think that someone who's African American going into a jail would say, I'd like to join the Aryan Brotherhood, mark me down as an AB?
Objection, relevant.
Well, I mean, you understand that there are racial reasons why people join particular groups in jails, right?
Objection, relevant, and outside the scope.
Your Honor, he testified that
This is outside the scope of the expertise. I think that my understanding from both parties that the purpose for questioning this witness is to determine whether or not he's an expert in whatever field he's being presented, which appears to report that he's being presented as an expertise on gang affiliation or gang classification. And then the other question the court wanted to know was, how would that be relevant to this case, whether or not it's tied to your client or not?
He said you use Google.
Remain within the bounds of this actual hearing.
Your Honor, I think that pretty well establishes what my objections be. I'm ready for argument.
All right, court will hear argument.
Your Honor, the witness is not sufficiently familiar with this organization to be able to give an opinion about whether or not it truly is a criminal enterprise and whether or not Mr. McIntyre is even still a member of it. He has a notation from a database that is no longer considered active by the database, that when he was first booked into Tarrant County or at some point in the past while in Tarrant County, he
Yeah, we
was
definitely are.
affiliated
Andy.
with this organization. We're backdooring hearsay. I have no ability to confront the individuals who screened him, or as to how he was screened, or whether he even got to participate in the screening process, or whether it was done for him. The witness has no personal experience with anyone affiliated with the organization. He's basing this off of what's basically a trade publication.
It's gang
from someone
experts.
in law enforcement in
Man.
Southern California, without any understanding about how that relates to San Antonio or Texas generally. And I think that under those circumstances, he's not qualified to testify about this organization for any purpose. It would backdoor in hearsay that violates the confrontation clause. And its prejudicial effect is through the
Can we
roof.
outlaw gang
And
experts?
there's
I'm
not
sick
even
of
any
them, man.
indication that Mr.
Y'all
McIntyre
do
is still
something
involved
else.
with these people.
Be an informant or something.
This is what the court's question is. One, gang affiliation is allowed as relevant information during punishment. The court is finding that this is relevant, but the next question the court wants some clarification on is, when is this alleged affiliation to have occurred?
Sure. So I have the exhibit that I would offer through this witness, but it was when the defendant was incarcerated in Tarrant County back in 2017. And I mean, he hasn't been out on the street since, so I think it's relevant. It goes to evaluating the defendant's background and character, which defense has put at issue in his opening statement when he was proffering that the jury was going to hear that the defendant had such a rough upbringing. And this witness is an expert. He has a lot of knowledge dealing with gang members and specifically the Crips. I think Mr. Hunter essentially stipulated that this is a subset of the Crips criminal street gang, and this witness is familiar with that.
But how does he
criminal
know?
street gangs, violent and illegal?
How does he know that though? If the only person he knows of is TAY, and he said he looked on Google to figure out the rest. He's over there screenshotting IG stories like Vivarito. That's crazy,
which
man.
he's
I can't
testified to,
stand
and
these gang
he
experts.
is able to form an opinion based on the materials that he's reviewed as to the defendant's membership in the organization.
I'm not stipulating to anything. This all is conduct that occurred after the offense date in this case, while he was incarcerated. And the witness is, I don't believe, qualified to tell the jury anything about this organization, much less whether
I
it's
agree.
affiliated with any criminal entity that calls itself Crips, or what its purpose is, or who its membership are, or whether Mr. McIntyre is a member. And so while I would agree with Your Honor that if we had evidence that Mr. McIntyre did this as a gangland shooting, it was for the purpose of advancing a criminal enterprise, it would absolutely be relevant. There is no relevance to the fact that he was booked into Tarrant County and someone says that back then he identified as being part of this organization. I think that is not relevant. And all it does is to make people believe impermissibly that because of decisions that he made in jail, which you can't really even say are criminal or underhanded, that somehow should have bearing upon how he's punished for this offense that occurred before he was even documented to be a part of
So it's not required by law for it to be relevant as character evidence that the offense that we're here for is tied to his gang admission. And it's not somebody just saying this. The defendant said it back when he was in Tarrant County. And so it's a statement against interest, a statement against party opponent. And I mean, this evidence has been filed with the court since December of 2024. So his objections to hearsay and stuff, I mean, there's an affidavit that is going to authenticate this information.
It more to the point is a Crawford, it is a confrontation issue because it's a double hearsay problem. They're offering the statement as an admission by party opponent. All right, fine. But what's being discussed here is not the actual admission by the party opponent. Being discussed here is the entry by a data clerk that he should be classified as a member of a gang that is in the text gang database because of something he said at booking. We don't have the statement exactly that was said at booking. We have a summary of that. So I think that that's the reason why there's a confrontation problem, irrespective of whether it would come in as an exception to hearsay or non-hearsay statement. But more to the point, I mean, she said a moment ago that it's somehow connected to the offense. There's been no evidence at guilt innocence that it's connected to the offense. I don't.
Does it have to be connected to the offense?
Well, I mean, I think she
And I
argued
can
it
say, I
was.
did not say that. I said it is not required
I
by
didn't say
law
that.
to be relevant in punishment to come in. That's not required, that I prove that he was acting under the color of his gang when he committed this
I know you
offense.
said that too, but did you not also argue?
And if
that
not, it's how is it
it's
relevant?
connected to the offense?
I did not.
Yes.
It's going to, the court is going to allow the witness to testify.
Dang, Judge Boyd.
No judge.
This guy's
All right, does
garbage.
anyone need a break, or I allow the jury to come back in?
I would like a bathroom break.
All right. So if I could have you all back here. 3:50.
What do y'all think about this, man? Wow, these gang experts kill me. Where is the... I think we're going to write a book. We're going to write a book as a community. Y'all all can contribute about gang experts and what it takes for someone to be qualified as a gang expert. So we'll get some criminal attorneys in here. We'll get some prosecutors in here to help us out with our book. And that way it can be used as a rule as to what verifies you or qualifies you as a gang expert. Because it seems like everybody got a gang expert. Oh yeah, you know, my cousin, he was in the Crips and I heard things, so I'm a gang expert. Come on, man. A gang expert should not be a job. Amy said, in that case, we all gang experts. I mean, they are never experts about anything. It's just what they heard. Yeah, what they heard on the street. Gang experts, these gang experts read Tukey Williams' book and they think they're a gang expert. What a joke. Cops watch 1 or 2 YouTube documentaries on a particular gang and all of a sudden they're experts. Man, get out of here with this. Wait till the appeal is filed. Going to be interesting. I wonder what I'll be interested to see that too. I 1000% agree, because we've got a couple of things they could use for an appeal here. And I don't know, it's possible TAY might be looking at another trial. We'll have to wait and see. Either way, I think we're going to call it for today. We're going to have a short live stream today. Appreciate y'all hanging with us, man. Thank you to everyone who liked the video and contributed as well. Shout out to Kara Hampton. Over 480 of y'all liked the video. I've got some news we're going to go over tomorrow. We've got some updates about Drake. We actually have a new lawsuit filed against Fulton County, which is crazy. And Sheriff Labatt is in trouble. It's looking like he's going to be in trouble as well. We'll talk about it on tomorrow's show. If y'all want to stay tuned in for that more, we're going to talk about Karen Reed. We'll talk about TAY and see what's going on with his actual punishment. What are they going to decide? Y'all stay tuned, subscribe, hit the notification bell if you haven't yet. And as always, I hope you guys have a great rest of your afternoon. Keep growing, keep pushing, keep it classy. We go. Peace.